What if the person who denied your medical treatment never actually read your doctor's notes? Not a summary, not a review, the actual clinical notes your doctor wrote, because in most prior authorization denials, that's exactly what happened. A computer algorithm or a nurse reviewer made the call, and your doctor, the one with a medical degree and years of treating you specifically, never got to speak to anyone. But there's a process that forces a physician at your insurance company to pick up the phone and defend that denial directly to your doctor. It's called a peer-to-peer review, and insurers are counting on you never asking for it. This video is for educational purposes only and does not constitute legal or medical advice. Here's the system you're actually dealing with. When a doctor submits a prior authorization request, most insurance companies run it through an algorithmic review first. Your diagnosis codes, your procedure codes, your treatment history all get matched against a criteria set, usually a proprietary one, built by the insurer. If the algorithm flags it, a nurse or a non-physician reviewer looks at a summary, not your full chart, a summary. And if that summary doesn't check every box on the insurer's internal checklist, you get a denial letter. The letter will say something like, "Not medically necessary." But here's what they don't tell you. That determination was made without your doctor ever speaking to a medical professional on the insurer's side. That's the gap, and it's a gap that costs American patients real money. A 2023 report from the Kaiser Family Foundation found that patients who don't appeal denied prior authorizations lose an average of over $10,000 in treatment costs they ultimately pay out of pocket, $10,000, for a process that takes one phone call to challenge. Now, insurers are legally required to have a peer-to-peer review process under federal regulations, including requirements tied to the Affordable Care Act and, for Medicare Advantage plans, CMS guidelines, but they don't advertise it. The denial letter won't mention it by name. It'll point you to a generic appeals process, which is slower, more adversarial, and designed to exhaust you. The peer-to-peer review is the faster lane, and most patients never know it exists. Here's how it actually works, step by step. 3 points, and each one matters. Point 1. You don't request the peer-to-peer. Your doctor does. But you're the one who has to make it happen. This is the piece that trips people up. The peer-to-peer review is a physician-to-physician call. Your doctor has to initiate it. But here's the counterintuitive part. Your doctor's office is overwhelmed. They submit dozens of prior auth requests every week. When one gets denied, the path of least resistance is to send you an alternative option, a different drug, a different procedure, or tell you the insurance company won't cover it. That's not negligence. That's a system under pressure. So the move is this. You call your doctor's office, not the insurance company first. Your doctor's office. You ask them specifically, has a peer-to-peer review been requested for my denied authorization? If the answer is no, you ask them to request one. Use that exact phrase, peer-to-peer review. Some offices call it a physician-to-physician review or a medical director call. Same thing. No. Here's the mechanism that makes this powerful. When your doctor's office calls the insurer to request the peer-to-peer, the insurer is required to connect them with a physician reviewer, not a nurse, not an admin, an actual physician, and that physician has to be qualified in a relevant specialty. Under CMS rules for Medicare Advantage plans, and under most state laws for commercial plans, the reviewing physician must have clinical expertise in the area being reviewed. That's a completely different conversation than the one that produced the denial. Your doctor is now talking to a peer, someone who understands the clinical nuance, someone who can be asked direct questions like, on what clinical basis did you determine this procedure wasn't medically necessary for a patient with this specific history? That question, coming from a physician, carries weight that no patient appeal letter ever will. Has your doctor's office ever told you about the peer-to-peer option after a denial? Drop it in the comments. I read every one. Point 2. The criteria set is the weapon, and your doctor can get it in writing before the call. Here's something most people, and honestly most doctors' offices, don't know. When an insurer denies a prior authorization, you have the right to request the specific clinical criteria they use to make that determination. This is protected under federal law. The No Surprises Act and ACA transparency requirements give patients and their providers the right to know what standard the insurer applied. Before the peer-to-peer call happens, your doctor's office should request that criteria set in writing. Send it by fax with a written request that says, "Please provide the complete clinical criteria used to deny prior authorization reference number, and include the denial reference number from your letter." Get it in writing before the call. Why does this matter? Because the peer-to-peer call is not a friendly conversation. The insurer's medical director is on that call to defend a business decision. If your doctor goes in without knowing the exact criteria that triggered the denial, the medical director can steer the conversation. But if your doctor has the criteria document in hand, they can challenge each criterion directly. They can say, "Your criteria require documentation of failed conservative treatment. Here is my patient's 12-month documented history of physical therapy, 2 failed medication trials, and a functional assessment score. Please tell me which of your criteria this does not meet." That's not an appeal. That's a clinical dismantling of the denial. Now, the specific notes that matter most in this call are what's called the medical necessity documentation. This is distinct from a standard office note. It includes the diagnosis and its severity, the specific treatment being requested, and why it's indicated for this patient, what alternatives have been tried, and why they failed, and a clinical statement of the consequences of not providing this treatment. Some electronic health record systems have a specific field for this. If your doctor's practice uses Epic, Cerner, or Athena, there's a prior authorization note template built in. Ask your doctor's office to use it, or to write a freestanding letter of medical necessity that covers all 4 of those elements. The more specific those notes are, the harder the denial is to defend on a peer-to-peer call. Vague documentation gives the insurer's physician room to maneuver. Specific, time-stamped, outcome-documented notes leave no room. If your insurance company has ever denied something your doctor said you needed, this is the kind of mechanism we break down every week. Subscribe, because the next one we cover is just as buried and just as useful. Point 3. If the peer-to-peer fails, the denial record it creates becomes your strongest asset for the next level of appeal. Here's the angle nobody talks about. Even if the peer-to-peer review doesn't flip the denial immediately, it changes the entire legal posture of your appeal. When a physician-to-physician review occurs and the denial is upheld, the insurer's medical director has now gone on record, verbally and in writing, defending that denial on specific clinical grounds. Your doctor can document what was said on that call. The insurer is required to send a written explanation after the peer-to-peer upholding the denial, and that document has to specify the clinical basis. Now you have something you didn't have before: a named physician, a stated rationale, and a standard they're claiming was not met. That's the foundation for an external review. Under the Affordable Care Act, if your internal appeals are exhausted, you have the right to an independent external review, conducted by an organization that has no financial relationship with your insurer. For most commercial plans, this is administered through the state insurance department or through organizations accredited by URAC. For Medicare Advantage, it goes to a qualified independent contractor, or QIC. The external reviewer is not bound by the insurer's proprietary criteria. They review based on generally accepted clinical standards. And the peer-to-peer record, where the insurer's own physician had to articulate a clinical rationale, is exactly the kind of documentation that external reviewers use to evaluate whether the denial was legitimate. The insurer's physician is now defending a specific position. And if that position doesn't hold up against published clinical guidelines, like those from the American College of Physicians or specialty society standards, the external reviewer can overturn it. Here's the number that matters. According to a 2022 report from the Department of Health and Human Services, patients who pursue external review win their cases approximately 40% of the time, 40%, or a process that is free, federally mandated, and takes about 45 days. So the full sequence is this. Denial arrives. Your doctor's office requests a peer-to-peer review. Before that call, they request the criteria set in writing. On the call, your doctor challenges each criterion with specific clinical documentation. If the denial is upheld, your doctor documents the call, and you request the written explanation. That written explanation, combined with your doctor's notes, goes into an external review request. filed with your state insurance department or directly through your insurer's external review process, which they are legally required to provide information about in every denial letter. Now, one more thing, because this matters and almost nobody mentions it. Timing is everything in this process. Most prior authorization denials have an appeal window. For urgent or expedited requests, that window can be as short as 72 hours. For standard requests, most states mandate at least 30 days, but the insurer's internal deadline for a peer-to-peer may be shorter. Call your doctor's office the same day you receive the denial letter. Do not wait. The peer-to-peer request needs to be made while the denial is still active and the authorization window is still open. The system is built around the assumption that you won't act fast enough. Prove it wrong. Here's the full picture. Prior authorization denials are not final medical decisions. They're administrative decisions made by criteria-driven systems designed to reduce payouts. The peer-to-peer review exists because regulators forced insurers to include a human physician-level check on that process. But it only works if it's requested. And it only works well if your doctor goes into it armed with the right documentation and the insurer's own criteria. You are not powerless here. The tools exist. The laws back you up. The process, when followed in the right order, gives your doctor a fighting chance to reverse a decision that was made without ever reading a single page of your chart. That's what the insurer is hoping you never find out. Next, we cover the step therapy protocol, the insurance rule that forces you to fail on cheaper drugs before they'll approve the one your doctor actually prescribed. It's one of the most widely abused prior authorization tactics in the country. That video is already on the channel. And if you've been through a prior authorization denial, tell me in the comments. Did your doctor's office ever mention the peer-to-peer option? Or did you find out about it somewhere else? That answer tells you a lot about how well the system is actually working.